to dismiss the case. She suppressed evidence. And I'll tell you what, if a judge does that, you can go and say, Your Honor, I might understand that this court is authorized to suppress evidence that's applicable to my case. Ask the judge. Say, Your Honor, I want you to place that on the record. I want you to make a plain, clear statement to me on the record as to what is going on here. I want you to state that this evidence is not admissible at trial for whatever reason you want to say. But I want your reasons. I want your findings and your conclusions. And you're required under the rules of the Supreme Court to give me the findings and conclusions as to why you denied me my due process. You have to know how to do this in a stand-up way. And it's easier for me because I do this all the time, but if you could just practice, and that's probably what we're going to be doing on our last day when we have our mock trial. What we'll do is I might play devil's advocate or something, or the opposing attorney, and I'll have one or more of you up there, and then we'll have a jury. And then if the judge, say, engages in suppression of evidence or suppression of witnesses or acceding to fraud, I want you to know how to object. I want you to know how to stand up and say, I object, Your Honor. Yes, Mr. Conces, what's your objection? This is a false and misleading statement. This is an unverified statement that the lawyer is making here. And then if the judge goes ahead and says, overruled, you say, I take exception, Your Honor, to the court's ruling. And I wish to preserve that issue for appeal. And I ask the court reporter to make a notation on the record that this will be an appealable court issue. So now you've got it on the record that the judge, you've asked him for his findings and conclusions why he overruled you. Why he always rules in favor of the IRS agent and never rules in your favor. You might ask him that, just for kicks. Let him answer. But don't, we want to stay away from the goofy stuff. And be respectful as you can. It's hard sometimes, it really is. Because the judges will do outrageous things. Like Ellen Carmody, she came out, the first thing she said to me was, Mr. Conces, well, she asked me if I was a lawyer, I said no. She says, Mr. Conces, in your pleadings you made a false statement. She said, you said that the DOJ attorney never made an appearance in this case. I said, no, that's not. She says, Mr. Conces, you made a false misleading statement. I said, that's incorrect, Your Honor. She says, Mr. Conces, this is my courtroom. She said, this is my courtroom. And she buzzed the guards. And Bill saw him come in and he's wondering, what are the guards coming in for? She wanted to have me objected and use that for an excuse to cancel the hearing. So you have to be aware of what they're doing. So I said that. I said, go ahead. So she went and made her statement, and when she got done, I said, Your Honor, may I now address that issue? She said, go ahead. So if you wait your proper turn, you'll be able to get in your thing. And I said, I didn't make that. That's not a false and misleading statement. I said the DOJ attorney was not or the United States was not the defendant in this case. It was the IRS. And the fraud perpetrated by the IRS officials. And that's when we get into that case that the IRS is barred by estoppel from claiming that they are a government agency because in that other case...
Chrysler versus Brown.
No, well, that was one, but the one where they claimed that they were not a government agency. They actually claimed in another prior court case that they were not a government agency. Okay? Now once, see, estoppel is this. And let me... No, forget Chrysler versus Brown. That's footnotes in Chrysler versus Brown.
That's where they said that they were not a government agency.
No, it was in the other case.
Oh, it was in a metal company.
Yeah, a metal, diversified metal case. And I read her, and I read the number of the case to her, and I said, in this case, the IRS claimed not to be... Okay, we're going to stop for just a minute, and I'll continue. A little break, stand up, shake around. And I'll tell you about estoppel. Estoppel. Okay, estoppel. Now these terms, let's just try to remember some of this. A bar or impediment preventing a litigant in certain situations from asserting facts or claims inconsistent with the facts previously established or with his own prior assertion or comment or conduct. So estoppel bars the IRS from saying in one court case they are an agency of the government, in another case say they aren't an agency of the government. And that's what I read to, I stated to Judge Carmody. And she never referred to it in her report. So in other words, she's concealing statements and evidence that would be used against the IRS, and she's involved in favoritism and cronyism with the IRS and their agents. And that's proof right there. So Judge Carmody is one of those judges that we have notified Congress has declared her defiance and rebellion against the U.S. court system and the Constitution of the United States and the laws of the United States. She has openly, on the record, declared her rebellion. She, by acts of defiance against the laws and Constitution. Therefore, she's not entitled to sit as a U.S. Judge, and she is not entitled to receive any pay or any retirement pay as a judge, because she's in bad behavior. She has brought ill repute onto the U.S. court system, and she has damaged the confidence of the citizenry in the United States court system. And she's violated her code of conduct. So how much more do you need? She has repudiated her oath. It means you can't sit unless you're going to honor that oath of office. Sorry, buddy. Judge Enslin acceded to her fraud and issued the dismissal of the case. He didn't dismiss the case. He wanted it refiled. But the question had never been answered whether the IRS can be sued or the suit must be against the United States. That question was never answered in that case. And Judge Enslin knows it. And I filed motions to address that question for full disclosure from the IRS or the DOJ, and they filed a notice of non-reply, a motion of non-reply. In other words, the DOJ wants to suppress the evidence too. Heather Richtarczyk, the DOJ attorney, flew out from Washington, D.C., and she spent all that money to come out and deny us citizens our due process of law and suppress evidence. That was her purpose for coming out here, and that's what she accomplished. Heather Richtarczyk is guilty of misappropriation of funds, federal funds, She is guilty of, by her actions, and I don't think she's going to deny her actions, of knowing of our pleadings and knowing that there is no constitutional provision for a direct tax on our citizens, and knowing of the 3 instances of fraud in our lawsuit. Heather Bertarczyk acceded to the fraud perpetrated by the IRS, and she became an accessory after the fact to the agents of the IRS. Now, we have come to expect this from our government agents. And that's why we have to notify Congress now. And if Congress won't do anything about it, we're going to notify them that they vacated their office. And if we get to the point where no government official will uphold the laws and the Constitution of the United States, then we need to call for a general election to elect new officers to every one of those offices. I mean, let's not play games. This is not frivolous. They've done it by their own action, period. And we can prove everything. That's why we lay the paper trail on these people. Because we know they're going to do it in advance. So we lay the paper trail. So now you know what estoppel is. If I claim in one case that I am not a citizen of the United States, and in the next case I claim that I am a citizen of the United States, I'm barred by estoppel from the second claim. That's why I tell you, don't say you're not a citizen of the United States, because the United States, the laws of the United States and the Constitution of the United States apply to U.S. citizens. It doesn't apply to non-citizens. There's been a terrible misreading in the patriot movement of that whole issue of U.S. citizenship. They believe falsely that if they claim that they're non-U.S. citizens, that they're not liable for the income tax. Well, the exact opposite is true. I could show you the regulation. I've seen the regulation. I didn't save it, I didn't file it, but it's in Section 1 of the Internal Revenue Code, the regulations. It says anybody who renounces their citizenship is liable for the income tax. So if you have renounced your citizenship in the past, make it known that you are a citizen, U.S. citizen from that point on, that you were misled into making that false statement. Okay. Well, we're being misled into all kinds of things, but here's the Internal Revenue Code. It's thicker than the Bible. And this is just to impose a few taxes. The Bible tells us how to live our entire lives. And the 10 Commandments take up about 2 pages. This is, you know how many pages are in here?
7,000.
I think it's 9,000 something.
Oh, is that
Yeah.
the one?
It's almost 10,000.
It's almost 10,000. And why did they mix up alcohol, tobacco, and firearms taxes in the same book, interlead them with income taxes? To confuse the population. That's the only reason they did it. If they asked me to write an income tax law that they're trying to apply, I could write it in about 5 pages. 5 pages. You wouldn't have to have indexes and all this junk. Yeah, I could make it a big writing with double spaces, yeah. So, and this is like 10,000 pages. So, even the IRS commissioner have said that they don't understand the income tax laws. Well, if they can't understand it, how can they apply a law that they can't understand?
Right.
So, I want to also tell you, all of you should get something of this kind. It's a legal dictionary. This one is put out by Random House. It has more than 3,000 entries, clear, comprehensive definitions, current legal terms. I'm telling you, this little book is a gold mine. This is how I really got started, because I bought this little dictionary and I started reading these things, and it was Wonderful. You know that there's constructive knowledge, and there's actual knowledge, and there's real knowledge. You didn't know all that, but you can find it out here. You can find out all what a sample is. You can find out what latches are. Yeah, Random House Legal Dictionary. My gosh, it's so handy, you know, if you want, you take it to work. On your lunch, you might want to read. You just start reading some of this stuff. Well, here's one on objection. A formal statement or notice that one regards a claim or procedural step as impermissible or invalid. They request that a particular course of action not be permitted or pursued. And then it goes on explaining objections. Here's a continuing objection. Did you know that there's such a thing as a continuing objection? A single objection applicable to all questions in a line of questioning. Supposing a lawyer on the other side has a line of questioning, and that, I want you to start thinking in terms like this, a line of questioning. We'll go through that probably on the last day and other times. But a continuing objection would say, Judge, Your Honor, I register a continuing objection to this line of questioning. Just tell the judge that. And then if he says overruled, you say, Your Honor, I take exception to your ruling, and I ask the court clerk to register my exception for appeal. So if you know some of the stuff I've told you, even if you remember half of it, you're way, way ahead of the general population. Way, way ahead. Objective test. Obstruction of justice. How many times do we you know, supposing you think that the judge is obstructing justice in your case, I would get up and say, Your Honor, I have a legal dictionary here. I'm going to read you the definition of obstruction of justice, and I want it read into the record. The crime of attempting to impede or pervert the administration of justice. Who administers the justice? It's the judge. Is he impeding or perverting the justice in your case? As by concealing or falsifying evidence. How many judges have concealed evidence? How many DOJ attorneys have concealed evidence? You read them the definition and say, I wish the DOJ attorney to be charged with fraud, with obstruction of justice. I mean, these laws can be used against the citizens, but they also can be used against any official that does the same thing. They have no right to disobey the laws. I mean, I asked a guy not too long ago, I said, what is the point of a preliminary hearing? And now we're going to get into our stuff, but we'll get into the tax court. Remind me about the tax court. The fellow that, who was it? Okay, remind me about that a little later, okay? Because we want to talk about the tax court. Okay. We want to look at the court. We want to look at what the court system is designed for. All the rules of court, if you look at it, I think it's the first rule of court, says the rules of court are rules of common sense. They're designed to get justice in cases. That's the rule. That's the purpose of the rules of court. They're not meant to be mechanical things that obstruct justice. or keep evidence out of trial, or witnesses out of trial. That's not the purpose of the rules of court. So I want you to start thinking in terms of what you can do in the various stages of a thing. From the first time you're ever notified, say, by an IRS agent, whether you're on defense or whether you're on offense. And most of us in the lawmen now are going on offense because we know how to do it. We can do it with a criminal complaint and we can do it with a civil lawsuit. But I want you to start thinking about court procedures and how it's laid out. Okay, first of all, before you ever go to court, you're going to win your case ahead of time, before you go to court, if you do the proper things. If you get into the goofy arguments, you're almost guaranteeing you'll lose your case. It's almost a guarantee. And you won't have any recourse. Because the judge can always say, well, you didn't even know what you were talking about. You said the 14th Amendment made you a slave. That's untrue, Mr. Conces. You're an idiot, Mr. Conces. Get out of my court or go to jail. Whatever you want. Take your pick. So you need to stay on point and you need to use the right, proper arguments to show the court that you are competent right from the beginning. Now, I asked this gentleman, what is a preliminary hearing? I'm going to put a box down here a little ways because there's stuff before you come to a preliminary hearing. I asked the gentleman, what is the purpose of a preliminary hearing? He said to me, so the government can gather evidence to use against me and convict me. Yeah. And I laughed because it's so funny. Preliminary hearing is the hearing that is your right. It is your right to demand all the evidence and the witnesses from the other side that they are going to present. It is your chance to present all your evidence and witnesses for your side. So now, this is where everything is laid out on the table. You're telling if you're being prosecuted, you want to sit down with the prosecutor at the preliminary hearing, and you say, I want you to provide me with this, this, and this. Let's say like in a case where you were falsely arrested. Okay, you sit down with the prosecutor and you say, I want a copy of the arrest warrant. I want a copy of the statement, the oath statement that provided probable cause for the arrest warrant. And the prosecutors are going to say, well, no, we don't have that. We can't get that, or it's not available to us. I say, no, I want it. I demand it right now. If you can't give it to me, I want you to get it for me. If you don't have a copy of the arrest warrant, and you came out to my house and you arrested me, that's a false arrest. And you tell that to the prosecutor, and you have a witness or two witnesses sitting there at your preliminary hearing. Because what is the preliminary hearing really supposed to do? It's the same as a arraignment hearing. It's supposed to determine whether or not there's sufficient reason to proceed onto the court trial. If you're on defense and they can't provide you with a copy of the arrest warrant, they lose. They can't say, well, there was an arrest warrant issued. Okay, you want to know, what is the name and title of the person who issued the arrest warrant? I want the name of the judge. I want a copy of the oath statement. I want to know what was the probable cause for my arrest. Okay, so that's our constitutional right. In fact, you know, it's interesting because more and more on the radio you hear issues like this. On the way up this morning, driving up, there was a circuit court judge in Michigan that said an arrest warrant couldn't be issued without probable cause because they were trying to circumvent that in the state of Michigan. And so we got a nice ruling by a judge. There are honest judges, and there are judges. All the judges know that they can get in big trouble by violating precedence law and violating the Constitution. They all know that. Well, let's make them real aware of it now, because we're going to file notices with Congress that these judges have vacated their office anytime they violate the Constitution. Anytime. If they issue an arrest warrant without probable cause, or if they honor an arrest warrant without probable cause and without an oath statement by your accuser, you want to say at the preliminary hearing, I want the name of my accuser. I want his title, his badge number, or if it's a citizen, I want the name of the accuser. I have a right to confront my accuser. If you don't have an accuser, sir, you don't have a case. If no one can swear by first-hand knowledge under oath that I committed a crime, you don't have a case. Let's repeat that. If no one can swear under oath that they have personal knowledge that you committed a crime, there is no case. It just doesn't exist. That is our constitutional right.
Say that again, Chuck.
There has to be an oath statement signed under oath by an accuser that they have personal knowledge that you committed a crime. They have to identify the crime. And in the case of criminal law, they have to strictly take the strict construction of the statute and regulation. I just found that yesterday in Mirsky, U.S. versus Mirsky. Bill, this is a good one. It's a statement that says, in criminal matters, look it up in Mirsky. I've got it, I put it into my case.
How do you spell Mirsky?
Strictly construed. I mean, according to what the written law is. You can't try to add things in or extend it beyond what it's named, the person's named, and the actions named.
Again, in criminal matters.
In criminal cases. I put it into my criminal law file, so anybody that will have my thing, it'll be right up at the top of the criminal law, important criminal law files. But that's U.S. versus Mirsky. You can look it up yourself. Yeah.
Chuck, if somebody lies on a ticket or citation,
Yeah.
have they already perjured themselves, or that?
Oh yeah.
They
Because
take the courtroom?
they sign that complaint under penalty of
Can you get
perjury.
them to admit it again in court and perjure themselves?
Oh yeah, you question them on the stand. You question them on the stand. And you say, you made this statement, sir, right? And
You accuse me of this.
yeah, you accused me of this. And now I want you to verify for the court what basis you had for that accusation. If you can't verify it, sir, it's just an allegation. It's not something you have personal knowledge of. See, they're afraid to put themselves under oath because they lie. The lady in Calhoun County, she said that when she was in front of Judge Bell, she had an official from the Department of the Mint, or one of the government agencies that does the printing of money.
Treasury?
I guess it's Treasury, yeah. Anyway, she had him on the stand, and the guy said, of course this wouldn't be admissible, but he said on the stand that if they got a statement from an official by the federal government it probably was a lie. He just simply came out and said that. That's what she told me. And I'll tell you what, anybody that thinks that here is hearsay, raise your hand. Nobody? It is hearsay. That's all I did. I give it was hearsay. It wouldn't be admissible. I told you it wouldn't be admissible at trial. It wouldn't be admissible at trial for that gentleman to say that. It's too generalized of a statement. If the guy got up on the stand under oath and he said that so-and-so who works in the Treasury Department made this statement and that is provably false, and I can prove it by these facts or laws. Okay, I can prove it. Then that would be admissible. But you never make an affidavit or a statement under oath unless you know it your own self. First-hand knowledge, not hearsay. So one of your objections in court will always be, objection, Your Honor. Yes, Mr. Conces. That's hearsay. It's unverified hearsay, Your Honor. Objection overruled, Mr. Conces. Your Honor, I take exception to your ruling, and I ask that the court reporter enter on the record that I take exception to your ruling and to make a note on the record that I make exception or objection to this hearsay and this unverified statement. So you need to be able to stand up and say, I object, Your Honor. I see guys in trial trying to defend themselves. Not one objection, not make one objection during the whole trial. That's pathetic. That's probably the basic number one thing is objections. And we'll go over these on, I think, the fourth day. But let me just take a note up here. Objections. Let's get back to our preliminary hearing. Preliminary hearing is for the purpose to see whether or not there's enough evidence and law to proceed on to court trial. Supposing I was brought up for evasion of income taxes, and they had a preliminary hearing on me, I would go. And the judge asks you the question, Mr. Conces, do you understand the charges against you? No, I don't, Your Honor. What don't you understand about the charges against you? Well, Your Honor, first of all, I know that in order for a law, that there has to be a law that I violated. There has to be a criminal law. And I know also, Your Honor, that there has to be a statute and a regulation before that law applies to the general public, which is me, Your Honor. I'm part of the general public. I have not been presented with a statute and a regulation that I have violated. At this point, the prosecutor hasn't done it, the IRS agent hasn't done it. Nobody's done this, Your Honor. So how can I be charged with a law that doesn't exist as far as I know? Now, if the prosecutor or the IRS agent wants to present me with the statute or the regulation and that I have violated, then I will be able to state that I understand the law, what the charges are against me. Until that point, Your Honor, I can't state that I know what the charges are against me, because I don't know what the charges are against me. The judge will probably say at this point, I'll enter a guilty or a not guilty plea for you, Mr. Conces. No, Your Honor, I do not want you to act as my lawyer. I do not want you to act in my behalf. I am acting in my own behalf. And on my own behalf, I am demanding to be presented with the statute and the regulation that I have violated. I have this right. That's part of my due process right, Your Honor. Until that point where somebody in government here presents me with that, and that, and my accuser, I want to confront my accuser, so have my accuser do that. So now you've got him on two things. You want the statute and regulation, and you want him to present you with your accuser. I called Cindy Newen out in Las Vegas. I said, Cindy, who is your accuser in this? She said, I don't know. United States of America. I says, really? Did the United States of America sign an oath statement and give probable cause? The United States of America can't pick up a pen. Cannot think a thought. The United States of America is an entity that is not a real flesh and blood thinking person. It is an official entity. It's a fiction, but it's still an official governmental entity. But it can't do anything unless somebody moves to provide an oath statement and accuse me of a crime. So Cindy was supposed to write up something and make a motion to the court that she had not been able to confront her accuser. I don't know what she did on it. She said she would get busy on it that week, but I haven't heard back from her since. But anyway, this is the sort of thing that you should be aware of and you can use as your defense. I want you to be aware of another defense. If they, about 15 years ago, the DOJ and the government started prosecuting people under the United States of America. Before that time, it was always the United States. Well, why did they switch from the United States to the United States of America? Corporate. No, it wasn't corporate, no. There is I think there's a government entity called the United States of America. But we're not under its jurisdiction. Its jurisdiction extends over Guam, Puerto Rico, the territories, and Washington, D.C. Okay, I'm not sure what laws are in the books for the United States of America. If we look at the United States codes, those are laws of the United States. Now, if they try to say that the United States of America and the United States are the same exact thing, challenge them. The Constitution of the United States says that this Constitution is ordained for the United States of America, right? Okay, so in other words, it's ordained for this entity, the United States of America, which would include Guam, Puerto Rico, Washington, D.C. But the laws and the authority were given to the United States. Look, read through your Constitution. It says the United States may do this, may establish courts, may do this, may have a judiciary, and an administrative, and a legislative body. Where does it say that the United States of America may establish a legislative body? And don't think I'm being facetious about this, because lawyers will pick on words too, and judges will too. I mean, if you're not exactly precise, you get kicked out of court or you get prosecuted. You need to know what to argue. But I'm saying that's a whole argument all by itself if you want to do that. And it's based on the Constitution. All powers were granted to the United States, none to the United States of America. Why did they change? Because they want to pretend as though we are subject to the jurisdiction of the United States of America. All you have to do is challenge jurisdiction in your case and say, I want this case vacated, or I make a motion to vacate, not vacate the judgment, well, it could be a vacate of judgment, but to dismiss the case based on the fact that the United States of America was not given any authorized powers by the Constitution. Only the United States. So let them prosecute you under the proper name if they're going to do it. The United States. Yes.
As well, they can't dismiss a case when you make a jurisdictional challenge unless they answer the challenge. This is what the court says. A case cannot be dismissed.
That's if you're the plaintiff. I'm talking about the defendant. You're challenging jurisdiction of the United States of America over you as a defendant. You're saying, This court must settle that matter before the case can proceed any further. I'm really very happy about this. Two of our members down in Mississippi, very nice people, very wonderful people. I did this, and United States of America versus da-da-da. Not me, okay. The Honorable Carl J. Barbier in New Orleans. Petitioner, Charles F. Conces, next friend to these folks. My address, my phone number. Amicus Curiae brief on taxation. So I've got an amicus curiae brief, and the title of it is Brief on Taxation. So I'm attaching the brief on taxation to this filing, this court filing. And it's not only the brief, but it's a petition to the court. Now, if you are engaged in the suit itself, you would make a motion to the court. You have a right to make a motion to the court. You motion the court to move on something. In this case, I'm not involved up until now. And I don't make a motion, so I make a petition. You have to first enter yourself into the case as a petitioner for a reason. And then I have a judicial notice. So there's three things in this filing, included with this filing. My first is judicial notice of appearance. This is the same thing that Ellen Carmody was trying to say, that the DOJ had entered an appearance in the case. No, they never did. I know what an appearance looks like. Appearance is a statement saying, here I am, making my appearance, and for these reasons. DOJ never said that, never entered anything in their appearance. The IRS was the agency that we were suing. Anyway, in this case, I refer myself as Charles F. Conces so that there's no question about who's who. Appears in this case as a best and next friend of these folks. And as the chairman of the National Lawman Committee for the Public Interest. Now, so I'm making an appearance as next and best friend to these folks, plus I'm appearing in the public interest of the country, of all our citizens. It is in the interest of the citizens of the United States that the laws and Constitution be properly understood and upheld by all U.S. District Courts, including yours, Judge Barbier. For this reason, and for the common good, petitioner Charles F. Conces appears and presents the U.S. Supreme Court rulings that affect this case. This person has been named as the party under attack, and his wife is the innocent spouse who also suffers under this attack. So now I'm saying, I've even given the judge an out because the spouse is innocent. If they're filing this against only the gentleman, and they're taking the property belonging in common between the two of them, husband and wife, then she is suffering as an innocent spouse. So I'm giving the judge a little bit of an out here. He might throw the whole thing out, their case against him. They're seizing all his property, by the way. So that was the first thing, is a notice, judicial notice of appearance, and why I'm appearing. Then now I do petition to vacate any and all judgments against this man for court's personal and for lack of court's personal and subject matter jurisdiction. Now, as long as we're here, let's talk about jurisdiction. In order for a court to have personal jurisdiction, they also have to have subject matter jurisdiction. Any subject matter jurisdiction failing is normally a personal jurisdiction failing of the court. So we're talking about subject matter. Now, just think about it. Subject matter jurisdiction. And then we only need to put personal jurisdiction here. Because and this is the court's jurisdiction. So this is for the court. And jurisdiction must be established by pleadings sufficient. By pleadings sufficient of the plaintiff in the case, which in his case is the United States of America. Now, first of all, he doesn't know who his accuser is. He has never seen an oath statement giving probable cause. I know that what happened was they bypassed the normal due process procedures. Normally, say like if the IRS is going to seize your property and notifies you that they're going to seize your property for some reason or other, whatever reason, they have to go to a court and get a judgment against you. And without that, everything is just hearsay and unverified. There's nothing that is on the record that would authorize a taking of these people's property. And that's basically what I'm saying here, but now I'm proving to the court that because they took it, that was a violation of his due process. And the argument is in my brief on taxation, because I attached my brief on taxation. I put that right at the end. And then I get a notary to sign my signature. And also, right at the end, I do a little notice to the court on the ruling Federal Maritime Commission versus South Carolina States Port Authority et al. Certiorari to the United States Court of Appeals for the Fourth Circuit, argued February 25th, 2002, decided May 28th, 2002. So it's a recent case. And it was written by Judge Thomas. And it says, federal administrative law requires that agency adjudication contain many of the same safeguards as are available in the judicial process. The proceedings are adversary in nature, which I've already told you. Now this is a statement from the judge. They are conducted before a trier of fact. So here we're talking, remember, fact and law. Trier of fact, insulated from political influence. Gosh. A party is entitled to present his case by oral or documentary evidence. And the transcript of testimony and exhibits together with the pleadings constitutes the exclusive record for decision. So saying the decision of the judge must be based on the documentary evidence, the transcript of the testimony. Testimony means under oath, and exhibits, together with the pleadings, constitutes the exclusive record for decisions. Parties are entitled to know the findings and conclusions on all the issues of fact, law, or discretion presented on the record. Well, here, a judge issued a seizure, a warrant seizure without proper jurisdiction, because the judge didn't know about all these Supreme Court rulings. Evidently, he's an ignoramus, which doesn't really surprise most of us, right? We're used to having judges that are ignoramuses. I know lawyers. I know a couple of them personally, and I'll tell you what, some of them wouldn't qualify to be a hole in a warm donut.
High regard.
Yeah. Well, sometimes I am tempted to call them morons, but I don't want to insult morons. So they're entitled to know the findings and conclusions on all the issues of fact, law, or discretion presented on the record. So now I'm presenting on the record all these Supreme Court rulings. And I'm saying, I want the facts and the law. Mr. and Mrs. So-and-so, they are entitled to the facts too. Because they were ignorant of all the research and ignorant of these court cases, doesn't mean that they had their due process. Their due process would be under full disclosure. The DOJ and the government concealed these court cases from the court. They were guilty of obstruction of justice, of concealment of evidence, and concealment of law. And I'm telling you, Your Honor, here is the law. And because of these court rulings, these two folks do not owe any tax debt to the United States. If you want to dispute any of these court rulings or the conclusions in the brief on taxation, feel free to do so, Your Honor. But you will have to argue that. And they are entitled to your findings and conclusions, and so am I, because I'm presenting them. And if you want me to come and testify on their behalf, I will. So it's, I make conclusions on the bottom. Number one, their labor and wages are their property. Number two, a tax on their labor or wages is a direct, unapportioned tax forbidden by the Constitution. Number three, they were denied their due process by seizure procedures that did not establish liability for the alleged tax. Okay, so those are the three conclusions I made at the bottom. And therefore, Petitioner Charles F. Conces respectfully requests that this honorable court declare that all seizures of property of these folks and all seizure proceedings, administrative and judicial, as lacking subject matter jurisdiction. Subject matter jurisdiction has to be established before a court can hear a case. The DOJ and the United States of America did not properly establish subject matter jurisdiction either in the prior court or in this court. In all seizure procedures, administrative and judicial, as lacking subject matter jurisdiction and rendered void and with no legal effect or consequence, Charles F. Conces requests an order returning all property to Ali and his wife. Okay, so that's being sent out in the mail now, and I've never done an amicus curiae before, brief, but I love it. And once I do something, then I learn it. See, that's the way you learn, by doing something.
It can be on the website so we can get a copy on it.
I don't put this stuff on the web. I could email it out to people, but I would have to ask their permission. This will be on the public. This will be on the public record, though. So actually, it's not private information. And I've already asked them for permission. I says, if I put your name out on the web, was that going to be all right with you? He says, sure. So I have his verbal approval. And he didn't know how to defend himself against this attack by the IRS. His wife didn't know. I know. Well, that's why we're here. Now we got to start someplace. And I know some of you are going to pick this up. Let me read a paragraph here. Paragraph 21. Additionally, this honorable court is obliged to vacate the judgment rendered against Ali and his wife by reason of the complexity of the statutes and the court's failure to construe the statutes most strongly in favor of them. The very existence of the above Supreme Court rulings and the U.S. Constitution should have been noted by the court in its deliberations, and failure to do so constituted a lack of personal and subject matter jurisdiction and lack of due process. It constituted that. And then I cite Gold versus Gold, 1917. In the interpretations of statutes levying taxes, it is the established rule not to extend their provisions by implication beyond the clear import of the language used, or to enlarge their operations so as to embrace matters not specifically pointed out. In case of doubt, they are construed most strongly against the government and in favor of the citizen. That's why I'm telling you, rely on our laws. We have a great system of precedence law and court procedures. We just got to learn how to use them. The lawyers aren't going to do it for you. You know what? The worst thing you can say about judges and lawyers is what Christ said in the Bible. Woe to you, judges and lawyers. That's the worst thing you can say to them. And by God, they're going to have to pay. They will have to stand before God, just like we will. If we fail to do our duty, if they fail to do their duty, if they inflict injury, unjust injuries on widows, families, orphans, businessmen, whatever they inflict, they have to stand before God, just like we do. And they better think about what they're doing. We're making them think about it. Guess what? This judge here, he actually ordered the IRS to respond to their pleadings. So we're getting judges to listen to us. We couldn't do it. I couldn't do this piece of paper if I was doing a goofy argument. So I was arguing the gold fringe establishes jurisdiction on a court. It wouldn't wash. The judge would laugh me out of court. He'd throw it out so quick, he'd say, this is garbage. So, subject matter jurisdiction must be established in any case that comes up, that is brought before the court, the U.S. District Court. There's another argument that some people use. They'll say, U.S. District Court is different from the District Court of the United States. They'll say it's a different court. That's baloney. How are you going to argue that in court? The judge will laugh at you. And then where are you? I've seen the guys go down in flames with the arguments, and this is why in the Lawman organization I insist, absolutely insist, that every one of our groups do not promote this kind of nonsense. We'll get people thrown in jail if we do it. This is not a game. It's not a silly little charade we're doing. This is the law, and this is the way it's applied. And how do I know? Because the Supreme Court of the United States tells me so. If we could rely on the writings of St. Thomas Aquinas or the moral authority of the church to argue in court, that would be fine, but we can't do that anymore. Judge won't hear it. So we need to argue based on the law, because our Constitution, when the framers wrote our Constitution, they understood what the moral authority of the religious arena was on the country. They established our Constitution under God. They established this country as a Christian nation, but allowing other people of other religions to exist perfectly fine as free people in our country. I find nothing wrong with that. I think it's the most wonderful Constitution of all the nations in the world. That's why at one time we were the greatest station in the world. Right now we're heading on the road to Bangladesh. We are losing our jobs because of these judges who want to keep this horrific IRS going and the horrific illegal taxation going because it benefits them. Well, we're not going to let them benefit themselves to the detriment of our citizens anymore. And people are picking up on this big time. I mean, a lot of people are picking up, and the judges and the officials know what's coming down the pike. We want to have those 12 operations managers of the IRS arrested, tried, give them a fair trial, and convicted. We want them to have them convicted, and we want them in prison. Bank fraud is one. 30 years. Carries up to 30 years. We want them tried. They've done so much horrific damage, and they refuse to listen to the Supreme Court ruling. And in their own Internal Revenue Manual, it says they must consider all Supreme Court rulings as if it were law. They have no option. And they refuse to even look at it. So, let's get to our subject matter jurisdiction. We need to do the jurisdiction. Now, you're going to make up copies of the jurisdictionary. That's a pretty good paper, and I think everybody should have a copy of that.
You got 32 in here.
32? Okay, good. Okay, good. We got a full room, which is nice. Any questions at this point? Because I'm going to go on to jurisdiction, but I want to know, okay, it is 12 o'clock. We should go break for lunch. And we'll probably take about 45 minutes for lunch. And then get back and hit it again on jurisdiction. And then I'm going to kind of walk through, make a diagram of the court. How the court system's laid out, what you're going to have to expect. See, you don't want to go into court not knowing what to expect. Then you're like somebody, they're just throwing things at you. You know, they throw this at you, and what do I do now? And we don't want to be like that. Okay, so that's the purpose of this class, so you know what to expect, what's coming up, what's the next due process procedure, and your due process rights. So is there any questions, and then we can break for lunch because it's just slightly afternoon. Anybody get questions? Boy, I must have explained this really good. You probably know everything. We could probably all go home.
When you said, when we're defending our case, and you say, Your Honor, I want this on the record.
Yes.
Well, what determines what they take off the record and what they put on the record?
They can't take it off the record if you want it placed on the record. If he's not going to place it on the record, say why? Why not?
Doesn't all testimony have to be placed on the record?
Yeah, that's what I thought.
Yeah.
That's all she's saying.
Oh, okay.
So why do you have to
Then
ask?
why do you have to ask them? I mean, if
Well, supposing the judge says to you, he overrules your objection to something. I was speaking particularly to objections that you make against your opposing guy. Remember, this is an adversary proceeding, right? When he makes a false, misleading statement or an unverified statement, you should be bounce up out of your chair and say, objection, Your Honor. And what if the judge overrules your objection?
Exception.
I take exception to your ruling, Your Honor. And I ask the court transcriber to preserve my exception for the record for appeals. So now you have that noted in the record that you have taken exception to the judge's ruling, and that's an appealable issue.
now as a pro se, do we hire our court reporter?
You can have your own court reporter in there. I don't see any problem with that at all. He can sit out in the gallery and be typing in the information. They're good. They're fast. And if it's a real important case, like your life depends upon it, I'd go go ahead and hire a court reporter. Either that or get a videotape, a demand that a videotape be made of the proceedings.
But they'll say that it's not of the proper quality.
Yeah, they did do that to one of our people in Manhattan. Oh, they did?
Yeah, with my case.
Oh, I didn't know they did.
We took it ahead of time, and we were told we got the highest quality that they offer at Radio Shack.
Well, see, there's
$15 for one, and they came and said, this isn't the right quality, ma'am.
well, ask her. Well, what is the brand name of the that's the proper
But
quality?
it was the day of the hearing.
Oh yeah, but you say, well, wait a minute. I want this videotaped, and you're trying to obstruct my due process of law, is to record these proceedings. I haven't got a great memory. I can't remember everything on the proceedings, but I want a record, and I want an accurate record.
So we could ask for it to be adjourned until we can get the right tape.
Yes, and ask her what is the manufacturer that has the right tape. I'll bring that in. You could ask them when you first apply. Tell them, I want you to tell me now what is the brand name of the tape that's high quality enough for your little sensitive little recording device.
See, that's the same thing that they do when people want to tape record something at a hearing. They'll bring up at the last minute that you had to tell them so many weeks in advance.
2 weeks in advance.
That you wanted to do that. They don't actually state that when they give you a copy of what you did.
Right.
But then they spring it on you at the last minute.
Right. And that's the prize. And that in any administrative hearing or court proceeding, if they surprise you with something, that is forbidden by the court rules. They aren't supposed to put up front all the issues. That would be an issue of recording your hearing. And if they all of a sudden surprise you at the last minute and say, oh, you can't do this, I say, oh, well, court rules forbid surprise. Now, either I go get a tape right now, or you provide an adjournment until I can get that tape. Don't let them walk all over you. We know what these judges are doing. These are communists.
Yeah.
They are communists. I mean,
one day I sent a motion in, and into the court, provided the other party, the defendant, with a copy of my motion, and he sent it back to me, stating that he said, oh, this must be your copy. Well, that was just a little trick.
Yeah,
to delay, that caused me more work, so I had to do the whole thing again and tell them that this is your defendant's copy now. So from now on, what you do is you write defendant's copy on their copy when you're in court.
And the judge's copy of
And the judge's copy. Yeah, no, yeah, now we don't.
Just pencil it, just print it, print it and underline it.
I think the pro se have more power because with a crooked lawyer, they go behind the chambers.
Yes.
And then they don't take you, the plaintiff, with you. You don't know what they're doing.
That's
Then they
right.
come out with their hands in their pocket during your trial because they cut a deal back there that I can't prove because I didn't get to go back there for my case. So now they want to do a little talk back there, then I go with them.
I know of at least 3 cases, personally, of cases where the person had hired a lawyer. The lawyer either didn't do the work or didn't do the filings or was incompetent, stupid, lazy, whatever, and they ended up with a lawsuit by the lawyer against his own client. So why would you want to hire a lawyer?
Right.
They're not going to represent you. Unless you can get a lawyer that will represent you and isn't afraid of the judge. But believe me, if you can find one of those, let me know. Anyway, so how are we set? We're setting pretty good. We got about 45-minute lunch break. You can,
I covered the bench.
Hey guys, out of 3.
I don't think all this is reading.
They said, oh, we're downstairs. Cold. Where's your blood at?
That's what I want.
All right, we're going to get started now. First, I want you this evening to go over the this paper. I think everybody should have a copy now of this introduction to the District of Idaho, U.S. District Court. Has everybody gotten a copy, or is the lady still? Okay, she'll be back with them. I asked her to have copies of these today. So it's a pretty good write-up, but it doesn't tell you everything. But look at their vision statement. Those of us employed by the District of Idaho take this mission statement very seriously. In order to provide the impartial and accessible forum that you are entitled to. Federal courts for Idaho are housed in the main courthouse in Boise and 3 satellite courthouses throughout the state. The address and phone numbers are as follows. And then it goes into the 5 required elements of a lawsuit, real injury, jurisdiction, which we're talking about now, statute of limitations, immunity, facts, and evidence. So it doesn't. Jurisdiction would cover the law as to what jurisdiction the court has. For instance, if it's federal law and it's deprivation of your constitutional rights, you want to go to a federal U.S. District Court. You don't want to go to the wrong court. It's not going to help your cause to go to small claims court on this, because basically you need to get exemplary damages. When you ask for exemplary damages when you're filing a tort action against an IRS agent, for instance. They have no immunity when you sue them in their personal capacity. When an agent steps outside of his authority, I have numerous law rulings that say when an agent steps outside of his personal authority, he has no immunity. 0. So remember that, and don't let lawyers try to tell you otherwise, or judges try to tell you otherwise. You cite those court cases to them. One was Galagos, I think, in New York. And that's in my important case law.
Right. Motion to strike. Their motion.
Yeah, Galagos, yeah. So what the lawyers on the other side, once you file a lawsuit, the lawyers on the other side are going to throw everything they can at you to get that dismissed. And the more smoke and mirrors they can produce, the more cover the judge has to dismiss your case. Because the judge is not favorable to you. We know that from experience in Western District of Michigan. So you have to take every one of the statements that the lawyer throws at you and explain why it's false, misleading, irrelevant, whatever. For instance, they like to throw the statute 7433 back at you and say that he could have filed a lawsuit under 7433, and that is his only remedy in this case. Well, it's his only remedy against the United States, but it's not his only remedy against a personal capacity suit against an IRS agent, is it? Because you're not suing the United States when you're suing an agent in his personal capacity. It is not the only remedy against an IRS official or the IRS. It is your only remedy if you sue the United States and if you access that statute as the basis of your lawsuit. But don't let them blow the smoke and mirrors at you saying that you don't you can't have any other remedy other than the 7433 lawsuit. That's just as bogus, baloney by lawyers. You've got to learn, before you do your lawsuit, if you want to do a lawsuit in his personal capacity, you have to be aware that you're going to get an answer back. The answer is going to probably contain almost all false and misleading statements. And in some cases, it's going to be perpetrating fraud on the court. And when a lawyer does that, you got to call them out. Say, you are the attorney for the defendant is perpetrating fraud on the court, and he knows it. Like in this last lawsuit we filed, the attorneys, this is a private company, by the way, the attorneys for the private company cited 2 court cases in their answer. They said these were unpublished cases. Well, what's wrong with that?
They don't exist.
No, they exist, but they're unpublished, and they cannot be used in any other case. They cannot be used in any other case. That's why when they dismiss your lawsuit, they want to put it in the unpublished category so that you can't cite it again. But we call the attorneys on that and said the attorneys are perpetrating fraud by citing unpublished case law. Just because the plaintiff is not an attorney, they're not entitled to perpetrate fraud on the court, and the court's not entitled to accept fraud in that case. Remember, I told you that you're going to win your case early on before you go to court if you do things right. And I have procedures that I like to use that really establish certain things. Boy, she gave, I don't know if this is all right. Yeah, that'll work. Okay, now these procedures are designed for a purpose. This one is designed to ensure that the judge can't come back at you and say you filed a frivolous lawsuit. Before you file in U.S. District Court, let's say the step down here is when you file. Okay, you file here. Well, what about before this step? How about in here? What could you do? You could write up your complaint. Okay, complaint. Now remember I told you that it might be, like, might be 60 pages. Let's just use that for an example. And you have your sworn statements under oath. And you also include your complaint any evidence. Like for instance, if you got a document that says Stephen P. Warner does not work for the IRS, and somebody named Stephen P. Warner signed the notice of tax lien on me. That's a piece of evidence. So you want to do your evidence with your complaint. Okay, you also have a brief. Now, does anybody, I mean, do you have a problem with understanding what a brief is? Well, what is a brief?
Supporting document?
Yes, it's a supporting document, but what does it contain?
Description. Description of the complaint that you're making.
Well, no, it's not a description. What else?
Kind of a blueprint, like?
No.
Summation of the laws that support your argument.
Yes, summation of laws, yeah. Yeah, a listing of laws to support your argument. For instance, I have a brief that I've done up, and we file that brief now. People can use that brief. Now, the brief on taxation.
Is that your 21-page report?
No, this is a brief. Report is not a brief. Okay, 17 pages, brief on taxation. And basically you could take this just goes through the history of the taxation, and then it has the conclusions at the end of the brief, just like I have in my 27-page report. Inescapable conclusions. Now, you attach this brief to your complaint. Your complaint's on the front. That might be 60 pages. You have your evidence. Say you have your letter from the IRS saying Stephen P. Warner is not an employee of the IRS. Maybe you attach your letter from the congressman down in Florida that said the IRS is not authorized to levy on a private citizen under 6331. That's evidence. And if they question your evidence, let them challenge it. You can always go get the congressman to sign a statement that he did issue that letter and send it out. But your evidence must be accepted as though it's true until it's challenged. That's why you have to challenge their statements. You cannot let them just say this, and this, and then you don't respond. If it's false, misleading, irrelevant to the case, you got to tell them that. Like 7433 would be irrelevant to the case. You have to explain why. Because your suit is against the IRS agent personally, his personal capacity, not against the United States. So 7433 doesn't apply in this case. But what I'm telling you, what I'm trying to get to the point of these things, what you do, you write them all up just like you go and take them into court. And you sign them, get your signature notarized, you walk them into the defendant, the company that's levying on your wages. You walk them in, you lay them on the desk, say, okay, you would not answer me. I asked you up here administratively to answer these things that I presented to you, and you refused even to talk to me. Okay, so now what I've done is write up the complaint, the sworn statements, my affidavits, my evidence, and my brief. And this is what I'm going to file in U.S. District Court. I haven't done it yet, but I'm going to, if you leave me no option. Now, I'm offering you this opportunity to sit down with me and discuss these matters. If you think any of the paragraphs in the complaint are frivolous, now is your time to tell me. If you think the case is without merit, now is the time to tell me. If you think the brief, you want to challenge any of the case laws in the brief, now is the time to do it, before I file in U.S. District Court. Now is the time to refute my evidence. Because what I'm offering you, the company or whoever you're going to sue, I'm offering you the opportunity to sit down and settle these matters outside of court. And if you won't do that, and you cannot refute my complaint, my sworn statement, my evidence, and my brief, then I have no choice but to file it in U.S. District Court. And send a cover letter with that and present it to the person you're going to sue, giving them the options. Now you're going to use the cover letter as part of your evidence. This will go into your evidence when you file it into U.S. District Court. That's evidence that you acted in good faith and the employer was acting in fraud. what this does